Good afternoon. People are still arriving. Feel free to take your time getting your lunch and taking your seats, but we'll go ahead and begin. It's my pleasure to introduce our 2024 McDougall Visiting Professor of International Law, Dr. Kenneth Mwenda. Dr. Mwenda is currently the manager and executive head of the World Bank Voice Secondment Program, which is a major capacity building program for World Bank member countries that are classified as middle and low income countries. He has been with the World Bank for 26 years, previously serving in positions including senior counsel of the legal vice presidency, working on lending and non-lending operations and financial and private sector development, as well as senior counsel in the integrity vice presidency of the World Bank doing anti-corruption work. He has maintained a career in academia as well, in parallel to his work with the World Bank. He has taught at a number of institutions in Europe, Africa, and the United States. And concurrently, he has appointments as Extraordinary Professor of Law at the University of Western Cape in Cape Town, South Africa, as well as Honorary Full Professor at the Graduate School of Business of the University of Cape Town, also in South Africa. He has been a prolific scholar over his career, publishing 30 scholarly books and 100 articles, most recently a book on public international law and a book chapter on capital markets development. So with that, I will introduce Dr. Kenneth Mwenda.
Thank you so much for that gracious introduction. I really appreciate. I want to thank the College of Law for hosting me. I drove in, actually I was receiving an award in Atlanta on Saturday, the weekend that I drove into Morgantown. I had to fly into Washington, D.C. and then connect. So there was no resting, and I had promised Allison that I'll be here on time, and I was here on Sunday evening around 10 p.m. I flew into DC about 3 p.m. I just connected. So that's my life. I'm always on the street or the road, so to speak, traveling. So today's presentation, first, I'm honored. The donor for this professorship, Archibald McDougall, was a Rhodes Scholar like myself at Oxford. I went to Oxford 70 years after him. So I believe he would have been very happy if he were alive to find that a Rhodes Scholar is actually the McDougall Professor for this year. So I'm really honored to be associated with that, and I'll share with my colleagues at Oxford, where I am Honorary Fellow at Exeter College. Now, we are looking at the legal status of odious states in international. This is a topic that's been addressed by a number of scholars and practitioners, including the World Bank, the IMF, and other international development institutions. But looking closely at this issue, what is the position of odious states today in international law? Because this issue has not been settled. Now, the objectives of the study, why are we looking at this? First of all, we want to examine critically the legal status of odious states in international law as it is today, and then secondly, identify the sources of international law on odious states. This is very important, especially for people who don't have a background in international law. Thirdly, we want to highlight the salient aspects of the common law on odious states and how they relate to international law. And finally, we want to provide international and comparative perspectives on prospects for the recovery of odious debts. This international and comparative perspective is important because very often we have to learn from best practices from other jurisdictions rather than having an insular sort of myopic approach to issues. Now, what are the sources of international law on odious debts? And I contend that there are only two sources of public international law that apply to odious debts. And these are customary international law and treaty law, or known otherwise as conventional international law. Now, Article 38 of the Statute of the International Court of Justice, which many scholars like to quote as providing the sources of international law, and I disagree with them, merely states that the ICJ can apply in deciding in accordance with international disputes submitted to it using Article 38. Now, Article 38 of the ICJ does not state that it contains or spells out the sources of public international law. Though many scholars, as I said, and pundits have often treated it as containing sources of international law. In reality, as I submit, there are only two sources of public international law. And these are customary international law and conventional international law. Now, for the benefit of the audience, let me provide you with the relevant text of Article 38 of the ICJ. There we go. The text says that the court whose function is to decide in accordance with international law, such disputes as are submitted to it shall apply. It doesn't say sources. Shall apply international conventions, which are treaties. They could be general or particular. International custom as evidence of a general practice and accepted law. There are two things about international customary law: general practice and what we call opinio juris. Opinio juris is the intent of parties to be bound by that custom. The court can also look at general principles of law recognized by civilized nations. But then what are civilized nations, we may ask? Also, the court, subject to provisions of Article 59 in the statute, can look at judicial decisions and teachings of the most highly qualified publicists of the various nations as subsidiary means for determination of rules of law. And then subparagraph 2 of Article 38 says that the court can also use what is called as ex equo e bono in making its decision. So let us take a more reasoned look. Nowhere in Article 38 of the ICJ is the word sources used. So we cannot assume what is not spelled out in the statute. Then the maxim ex equo e bono in Article 38, paragraph 2 can be translated in English as according to right and good. Put simply, ex equo e bono in public international refers to moral and ethical considerations made by the ICJ when the court opts to decide a dispute on the basis of equity and fairness, as opposed to strict legal formalism. Here, good versus bad, when you're making moral choices, speaks to moral issues, whereas wrong versus right speaks to ethical issues. So they are both moral and ethical considerations that the court can use, and it can step away from legal formalism. But then we are looking at odious debts. So what do we mean by odious debts? In public international law, the term odious debts refers to obligations of a state incurred by a previous regime or government for purposes that were not in the best interests of the state, such as wars of aggression. The leading theory in international law postulates that odious debts are not enforceable against the debtor. That's sort of the leading theory in international law. Now, odious debts are generally considered to be personal debts of the regime or government that incurred them and not debts of the state. Now, those of you who have work experience, you've drafted contracts before in international law, you know that when a country is borrowing, the legal agreement is usually between the lender and the borrower is usually a state. When you're drafting the agreement, it doesn't stipulate that the government says the republic or the state of XYZ. So usually the borrower is the state because governments come and go. If you deal with international law, there's also a difference between recognition of states on the one hand and recognition of governments on the other hand. Okay? So in some respects, the concept of odious debts is analogous to the invalidity of contracts at common law that were signed under duress. We are making an argument that if a despot or a dictator gets a loan for his own selfish interests, as an agent of the state, he's a head of state, he's acting on behalf of the state, but he's acting for fraudulent means to amass wealth or carry out whatever intent he wants to do. It's not in the best interest of the state. And therefore, that loan agreement, if the lender had knowledge of that intent by the borrower, is not enforceable. Okay. Now, historically, let's look back. Where does the story begin? The doctrine of odious debts in international was given more prominence in 1927 when a Russian scholar, Alexander Sak, wrote a treatise on this. It was based on 19th century precedents, including Mexico's repudiation of debts incurred by an emperor there, Maximilian's regime, and the denial by the United States of Cuban liability for debts incurred by the Spanish colonial regime. Now, I remember at some point after the Cubans fought the Spanish, Cuba was very briefly under US governance. Now, Sachs, the Russian scholar, argues that when a despotic regime contracts a debt, not for the needs or in the interest of the state, but rather to strengthen itself, to suppress a popular insurrection, etc., this debt is odious for the people of the entire state. This debt does not bind the nation. It is a debt of the regime, a personal debt contracted by the ruler, and consequently it falls with the demise of the regime. The reason why these odious debts cannot attach to the territory of the state is that they do not fulfill one of the conditions determining the lawfulness of state debts, namely that state debts must be incurred and proceeds used for the needs and in the interest of the state. Odious debts contracted and utilized for purposes which, to the lender's knowledge, this is critical, to the lender's knowledge, are contrary to the needs and interests of the nation, are not binding on the nation. When it succeeds, especially when the nation succeeds in overthrowing the government that contracted them, unless the debt is within the limits of real advantages that these debts might have afforded. The lenders have committed a hostile act against the people. They cannot expect a nation which has freed itself of a despotic regime to assume these odious debts, which are the personal debts of the ruler. Now, Sachs does not, however, clarify in submission, which I just quoted there. He does not explain what would be considered as knowledge of the lender. What is knowledge? How can we determine if the lender did, in fact, know the debts being incurred by the state were for personal use of the despot in power or wars of aggression? And I argue that what is knowledge? Is it actual constructive knowledge? And should we use criminal law or civil law test to determine what constitutes knowledge? If you look at the law of trust, for example, when you're looking at knowledge, the criminal law approach is different from the civil law approach. Debts considered odious when they are contracted without the consent of the people and not spent in the interest of the people, and when the creditor is aware of this. Sachs and many other scholars argue that such debts cannot be recovered. In many cases, states have taken on odious debts of former dictatorships as a result of political pressure or fear of being penalized by the creditors in the future. This can happen, it's politics, it's not even law. Because you feel like if we don't honor the obligations entered into by our predecessor, even if these guys did these things for their own personal gain, we might lose the favor of this creditor who we might need in future. We might as well just pay this debt. Okay. Now, there are, however, some clear precedents for odious debts being repudiated, such as Mexico in 1867, Cuba 1898, Poland 1919. Now, I pose the following questions. Can a state overburdened by foreign debt, for example, choose to repudiate the debt obligations entered into by a previous government of that state if creditors refuse any form of debt restructuring or cancellation through, say, arbitration? Because you may want to go to arbitration, but the creditor is saying, no, just pay us the money that you owe us. We're not interested in restructuring the debt. What are the rights of a state that is faced with such a situation in international law? And what are the rights of the creditors, on the other hand? Shouldn't creditors be required to demonstrate that their debts are not odious? Who has the burden of proof? Does the burden always have to fall on the debtor state? Are there any lessons of experience to share on how some states have dealt with the issue of odious debts? Now, let's take some case studies, real case studies. 1867, Mexican repudiation of Austrian debts. The Habsburg Emperor Maximilian contracted debts between 1862 and 1867 at onerous rates of interest to maintain his sovereignty over Mexico and suppress any uprising there. And in 1883, 16 years after the fall of Maximilian, the Mexican government under President Juarez repudiated the entirety of the alleged debt against them. Now, Honorary, who's an international legal scholar, mentioned that a large part of those debts were created to maintain that usurper in his place against the legitimate authority, and all of them were mostly scandalously usurious, meaning for personal use. Now, we move on to look at Cuba. 1898, U.S. repudiation of the Cuban debt after Spanish-American War. After the end of the Spanish-American War, the Cuban loan negotiations at the Paris Conference in 1898 is said to be the first direct application of the doctrine of odious debts. From 1880, Cuba incurred debts consisting of various loans issued by the Spanish government and secured on the revenue from the island. Spain asserted a principle of international law, which I explained earlier on, that state obligations belong to the land and its people, not a regime, meaning to say it's the state that is bound, not the government. And since the loans were secured on Cuban revenues, the issue between the US and Spain was whether those financial obligations devolved to the US when the Spaniards were defeated upon cessation of the territory. Spain attempted to validate the claim that the financial obligations did devolve to the US at the negotiations in the Paris Conference. The American commissioners who were representing the US replied that the debt was imposed upon the people of Cuba without their consent and by force of arms, and was one of the principal wrongs for the termination of which the struggles for the Cuban independence were undertaken. Further, the American commissioners added that much of the borrowing was designed to crush attempts by the Cuban population to revolt against Spanish domination, and so was expended in a manner contrary to Cuba's interests. The American commissioners posited that the debts were therefore odious and not repayable. This is their submission. From no point of view can the debts above described be considered as local debts of Cuba or debts incurred for the benefit of Cuba. In no sense are they obligations properly chargeable to that island. They are debts created by the government of Spain for its own purposes and through its own agents, in whose creation Cuba had no voice. From the moral point of view, the proposal to impose them upon Cuba is equally untenable. As such, the Americans argued, these debts could not be considered Cuban debts, nor could they be binding on a successor state. As for the lender, the Americans contended, the creditors, who are the Spanish, from the very beginning took chances of the investment because they had knowledge that this was being, they were financing this just for the purposes of the dictator, to maintain a dictator in power. Now, the Boer War in South Africa. The Boer Republic borrowed money in order to try to repel the British in South Africa. After the end of the Boer War, the Supreme Court of the Transvaal declared that the debts had devolved upon the British as the new sovereign. However, Britain refused all legal responsibility, denying that the Boer Republic could validly issue debt. Then we look at the Polish debts, 1919. The German government and its Prussian predecessor operated a fund to enable ethnic Germans to buy estates in Poland in order to colonize the Polish. Since few Poles were prepared to sell, the government enacted a compulsory purchase law in 1908 and issued bonds to finance the purchases. At Versailles, the Reparations Commission refused to charge these bonds to the newly liberated state of Poland as a just reversal of one of the greatest wrongs of which history has a record. Now, let's move forward and look at Costa Rica. The famous case, the Tinoco case, for those of you who are students of international. You'll find this case, especially when you're dealing with the issue of recognition of states and governments, a famous case in customary international law. After the fall of Federico Tinoco, dictator from 1917 to 1919, the new Costa Rican government passed the law of nullities to repudiate dates lent to Tinoco by the Royal Bank of Canada. Great Britain, a country that had an interest in this, challenged this, and the Chief Justice of the United States Supreme Court at the time, Chief Justice Taft, was the arbitrator. And he ruled as follows. The loans did not constitute transactions of an ordinary nature and which were full of irregularities. They were made at a time when the popularity of the Tinoco government had disappeared and when the political and military government aiming at the overthrow of that government was gaining strength. The 200,000 US dollars in loans were made by the bank to Federico Tinoco himself, the dictator, for expenses of representation of the chief of state in his approaching trip abroad, and as 4 years' salary and expenses for his brother, whom Tinoco had appointed ambassador to Italy. Therefore, the Royal Bank must make out its case of actual furnishing of money to the government for its legitimate use. It has not done so. The bank knew, that's the key word, the bank knew that this money was to be used by the retiring president, Frederick Tinoco, for his personal support after he had taken refuge in a foreign country. It could not hold its own government for the money paid to him for this purpose. So repudiation succeeded. Now, critical issues to consider. We've looked at the case studies. What are some of the critical issues to consider? The questions we need to be asking ourselves: are odious debts illegal or simply unenforceable under international law? What about the question of opinio juris in regard to the repayment? Are the cases that we've looked at simply state practice? Because on the one hand, we should distinguish. There are three things you look at in international law. For those who are students of international law, a good essay, if your professor in international is looking for a good essay, we look at three things: evidence of state practice, evidence of customary international law, and evidence of conventional international law. Those three threads should come out. Now, opinio juris on its own is not customary international law. General state practice on its own is not customary. The two have to be married for you to have customary international law. Even then, there could be some persistent objectors to that custom. It can be a bit complex. Even with treaty law, there are states that might issue a reservation to a treaty, unless it's an issue which is so fundamental that a state cannot derogate from that. Under the law of treaties, I think Article 35, you cannot derogate from norms of international law which are so fundamental that they affect everybody in the international community. For example, a treaty that is condemning or barring slavery, you can't say, we are reserving our right to sign this treaty. You're bound by that. Okay? We call that jus cogens in customary international law. What about the concept of unjust enrichment, where a country overburdened by debt repays odious debts that are unjustly enriches the creditor with no correlative benefit to the people of that debtor country? If you remember, we started off by saying the ICJ, the International Court of Justice, can use moral and ethical considerations apart from the law. So these are questions then that we should be looking at. Further, what about the Latin maxim, and this is the point I'm trying to make, ex equo e bono, enshrined in Article 38(2) of the ICJ statute, postulating that ICJ can decide a dispute based on ethical and moral considerations. If we take that into account, what are we left with? What about the issue of debt relief? Is there an obligation for creditor nations and institutions to provide debt relief to indebted nations on the grounds that the debt incurred was odious? The 1983 Vienna Convention treaty, the Vienna Convention on Succession of States in respect of state property, archives, and debts stipulates that by default, no state date of the predecessor state shall pass to the newly independent state. However, this convention or this treaty has not yet received enough signatures to enter into force, and probably never will, because it's been sitting there idle for a while. The original draft of that treaty contained a direct reference to odious debts, which shows some juristic acceptance of the doctrine in the international community. But the question is, has the said treaty crystallized into customary international law? There are some treaties, especially multilateral treaties, which can generate customary international law based on the practice of state and the opinio juris attached to that practice. So they can crystallize, that's the term we use in international, they can crystallize into customary international law. But has this draft treaty succeeded in crystallizing into international customary international law? One could argue that when a creditor contracts an odious debt with a dictator and enforces repayment, it commits an abuse of rights against the population of the debtor state. because you knew that you're giving this money to a dictator. So why are you trying to enforce this date? Indeed, if we advance the argument of international human rights, we can say that the right to development, though considered a third-generation human right under the school of thought of generation of human rights, is a part of the body of human rights law, and it cannot be ignored. So enforcing odious dates militates against the concept of right to development. Now, at common law level, remember at the beginning when we were looking at objectives, I cited the common law as part of the norms of civilized nations. At common law, the law of agency falls generally under, when you look at Article 38, of the ICJ, the law of agency will fall under there as general principles of law recognized by civilized nations. And I asked the question, then what are civilized nations? I'll explain why we've cited the common law doctrine of law of agency. The law of agency imposes mandatory duties upon one person, that is the agent, the dictator who's the head of state, who acts to create binding legal relations for another person, the principal, meaning the people. But those duties require the agent, that's the head of state, to act in good faith and for the benefit of the principal, the state itself. When third parties such as creditors assist an agent such as the head of state to violate those duties, they too may be held liable in damages to the principal. Okay? Think of trust law, the concept of constructive trust, where there's breach of fiduciary duties. Okay? Whatever monies are gotten can result back to the person who actually should be the rightful owner of those monies. Now, as we conclude, it is not uncommon for a new government that has come to power to seek to repudiate the dates of its predecessor government, which were incurred by a despotic leader. In such a situation, it remains unclear, however, if customary international supports the doctrine of odious dates for a state not to honor its debt repayment. Remember, we said the ICJ can look at the writings of scholars. The ICJ can look at norms of civilized nations. I spoke about state practice distinguishing from customary international. So there's been evidence of state practice, but we're not sure whether this has crystallized into customary international law. A theory does exist, however, that repudiation is possible if three conditions are met. One, the debts were incurred by a despotic ruler without the consent of the people. Very contentious. He's acting in his official capacity. He has apparent authority. Okay, if you look at the law of, common law principles of agency, if you have apparent authority, you can bind the principal. Are you exceeding your authority? No, he was probably acting within authority. Secondly, the funds were used in ways that did not benefit the populace. If that's the case, you can argue for repudiation. Thirdly, the creditors were aware of the likely illegality of the loans, but went ahead and gave the loan. So the state can push back to say, you knew that this thing was illegal, but you went ahead. So we're not going to honor your contractual obligations. Okay? Now, I'd like to submit that this theory holds water because such debts are contractually entered into by a debtor state, not its government, as I had pointed out earlier. It is the state, not the government, that is the party to the contract. So if the government is not acting in the interest of the state, but in the interest of some political elites, the government cannot hide behind arguments of apparent authority, purporting to be acting as an agent of the state since it will have abused its agency authority. Indeed, you cannot use the clock of the common law as an instrument to perpetuate a fraud. Thank you. Sure. Any questions? Oops, sorry.
In most cases where there is this type of debt, is it like almost always that the country who's loaning the money, are they almost always aware of the circumstances? 'Cause I know that's like a requirement. So, but is that almost always the case? Is it very unlikely for them not to know about the illegality kind of the funds?
Yeah, in most of the cases that we looked at, the lender, the creditor, did have knowledge that this guy was a despot, he was a dictator, and so forth. Um, but again, as lawyers, we need to ask ourselves, and that's the question I posed: are we going to use a criminal law test of knowledge or civil law? What kind of test are we going to do at international law level? Um, International replicates norms at domestic or what you call municipal law level. Okay. So, for example, if this would be criminality at the state level, it's more likely that even at the international, it will fall into the area of criminality. Okay. But again, we also have to draw a distinction between knowledge and notice at common law. Yeah, and it can be very complex if you get into case law to try and draw this distinction. It's not good enough to say they had constructive notice. No, it's knowledge. We're talking about knowledge, not constructive notice. But in most cases, yeah, the lenders have had knowledge of that.
I was oh, loud. I was curious to know how this theory would address um, quasi-authoritarian states or electoral autocracies, states that are kind of empowered to legally exercise the authority of the government, but aren't actually um, democratically elected, if that makes sense. States like Thailand or Russia, post-coup Thailand, I should say.
Great. Yeah, it's a great question. First of all, we have to step back and look at the issue of recognition of states. If that is a state, and that's in the Tinoco case, remember Britain refused to recognize the Tinoco government. So if the state has been recognized by the international community, including the other party to the dispute, it's more likely that you can't run away from whether the guy came to power. When there's a military coup, there are two important arguments in jurisprudence which validate claims for a successful military coup. One, the party that the regime that comes to power has to be in effective control. Secondly, the international community must perceive that regime as a legitimate regime. Once they do that and they've suspended the constitution, they are good to go. It's a state, whether there were elections or not, and that's what happens. But if the state or the government that has gone with a military coup is not in effective control, they are struggling, others are fighting back, that's not a regime. And you give loans to those thugs, it's at your own risk.
I had a question about moral hazard, and specifically with the idea of odious debts not being enforceable, for example, for the crime of aggression. If we have knowledge that these crimes aren't enforceable, that the debts aren't enforceable, doesn't that encourage states to engage in such practice if there's the knowledge? Or should we think of this more as it's encouraging lenders not to lend to states that engage in this practice?
Yeah, great question. Economists, this is a field in which economists have written a lot. They've done a lot of work. I think lawyers have been a little bit slow, apart from international lawyers, to sort of step in the arena. So the moral hazard question is principally law and economics type of question. And I'm sort of glad I come from that school of thought. So I'll take on that gladly. Yeah, it does create a moral hazard for states to run away from that, because then it means basically creditors have to continuously monitor these debts to ensure that they're dealing with the right party and acting in the best interest. And it raises the costs of monitoring from the lender's point of view, and the interest rate might be higher because you're increasing the monitoring costs. So there's a challenge to that. You're absolutely right. But like I said, customary international law is yet to be settled. But there is sufficient state practice so far indicating that once those three conditions which I spelled out, if I can go back, these three conditions which are One, the debts were incurred by a despotic ruler. If that's met, the funds were used in ways that did not benefit the populace, and the creditors were likely aware of this illegality. If those three conditions are met, repudiation is likely to succeed.
I love the second point there. And my
Sure.
question is, what lens do we use for it? Is it retrospective? Does it matter if at the time people thought it would benefit the populace? Do we only look back and say, in hindsight, that did not benefit the populace, even though that was the intention or even though that was the widely held idea at the time? And if it is a retrospective lens, is there a point at which it's like, yes, but who could have known that that wouldn't benefit the populace?
Good question. And that comes back to the question of knowledge. At what stage can we say the lender had knowledge that this was for illegal purposes? And I would like to argue that this has to do with a civil law test than a criminal law test. This is about a constructive trust, basically. That money was given for a fraudulent purpose and therefore should result back to the donor or whoever the beneficiary is. Okay, so the test that, in my humble view, would be useful here is a civil law test, if you're trying to determine, not beyond reasonable doubt, no, on a preponderance of probability.
I had a quick twofer, but are the creditors always states? And is the ICJ always the forum where people are arguing about repudiation, or is there another place?
Yeah, and the creditors could be financial institutions, banks, international development organizations, multilateral organizations, and so forth. So it's not always, there are bilateral loans from a state, but mainly it's financial institutions. Now, the ICJ usually deals with state-party disputes between states. So it will not handle these type of things. But the ICJ is useful as a reference because it has the main voice on sources of international law, as the main court in the international community. So that's where we start from. That's why we brought in the ICJ.
So I wanted to ask, towards the second point about benefiting the populace,
Yes.
many different despotic rulers will use populist tactics, such as providing free food from said ruler. I'm thinking specifically of Modi in India. Now, that's not necessarily a despotic ruler, but it does benefit the populace to then benefit by buy-in towards that despotic ruler. So there's some ambiguity there. Do you have any insight towards that?
Thank you for that question. I'm going to use an analogy in responding to that. Let's assume drug traffickers are providing free education. Are they immune from prosecution? No, they're not. So that's basically explains the position. So the fact that these guys are using populist tactics doesn't exonerate them from liability.
Of your 4-century-old or more examples that leads to your theory, 3 of them, Mexico, Cuba, and Poland, really can be answered by saying these were not true representations of the state. In Mexico, the state had been taken over from the outside by European powers that installed Maximilian. It really could not be viewed as the state of Mexico. In the case of Cuba, it was a colony that became an independent state and was in no way the state of Spain. All legal scholars would say this was a new state. The same would be true for that part of Poland that was part of the German Empire previously. The new Polish Republic was not Germany. Those don't seem to help too much when you're dealing with corrupt dictators in a government that is not looking out for the people, but is clearly within the same state. Tinoco, you oversimplified a tiny bit. Originally, there were two objections in Tinoco, that an unrecognized government could not incur the debts of a state.
Right.
And the first ruling by Taft was, oh, yes, it could. And it was only because the debts that were incurred were so outrageous, future payments for the president's brother-in-law or cousin that went years into the future, that the loaning bank knew about, that on the general basis of you're not a holder in due course, Taft could reject that. It seems this doesn't help a lot if you're talking about a hydroelectric dam project with many roads and thousands of tons of cement and wasteful spending and inefficiencies and some skimming by the government that looked like a valid project, but who knew that it would be done so inefficiently? Or at least that would be what the large banks would say. I don't think Mexico, Cuba, Poland, and Tinoco help you out much there.
Thank you for that question. To summarize the question in a nutshell, can we use arguments of corruption in a country as a basis of not acting in the interest of the state? That's the question. Now, there are other examples that I have left out. These are not for it. Yes, yes. So there are other examples, for example, the issue of Congo DRC, dates that were incurred when Mobutu Sese Seko was president. These are recent cases. We also have cases of balkanization of states, Yugoslavia. The dates that were incurred under President Tito, whether those devolved to the successor states. I don't want to go into that because some of it is data privacy. We're handling that at the World Bank and the IMF, so I avoided that deliberately. But they are relatively modern examples of these things. Now, coming back to the issue of corruption, honestly, if you go that route, that's stretching the argument. Almost all governments will get away with it because corruption is everywhere, including in the US. All governments will get away with it. So there are things that you can look at in international law to say, okay, when we look at the description of odious debts in the best interest of a country, right, there's a project, but there was corruption going on. Fine, this project was in the interest of the people. Okay, it was not used for personal gain, it was for the state, and therefore the state is bound. You know, I have not, in my study of international law for the last 40 years, come across any case where a country has repudiated a date because there was corruption. Impossible. That would be my response.
Okay, I don't really know anything about this, so this may be stupid, but it's related to something Cody said, Amy, and maybe a piece of Jim. In listening to this and trying to make sense of it, to me, the way to make sense of it was to view it all through the lens of how do we want the lenders to be thinking about these decisions when they decide to loan money, and what we're trying to do is deter lenders from basically funding the kinds of activities that would later qualify as odious debts under your definition, right? And if you look at it that way, it kind of has to be ex ante in relation to Amy's question, right? And then I would think the notion is, you would want to say something like, well, the standard is constructive knowledge because you would want to have some level of duty of inquiry on the part of the lender, and lenders would be hesitant to do these things. But then I would think the worry on the other side is if the demand is too great, you might wind up with a situation where there is less than an optimal amount of willingness to loan the money, and that might in the long term be bad for developing countries. So that was kind of like the way that I framed this in my head listening to you, and I'm just wondering if you think that's on track or
Yeah, you've summarized it pretty well. The issue of constructive knowledge. Look at fiduciary responsibility of the parties involved and whether there was a breach, and therefore, we can impute constructive knowledge. That's a more viable way, and that's why I raised the question: should we use a civil law or criminal law standard? And I was saying, let's go for a civil law standard. That would be a viable way to go. You're absolutely right. I agree. Any questions? I raised a very important question on the source of international law. Much of the literature you're going to read in international, they will tell you Article 38, 1 of the ICJ statute comprises sources of international, and I disagree. And my former professor at Oxford, Ian Brownlee, who taught me international, also disagreed. We both disagree. May his soul rest in peace. I was a student of Brownlee at Oxford. So these are issues that students, scholars need to think about critically. Words for lawyers matter. We work with words. Use of the word sources is a critical thing. If it's not in the literature, why are you imposing that word in there? Thank you so much.
I didn't want to ask this question because I feel I'm so underinformed that I'm probably not even appreciating how the factors apply to the test. But I'm moving a lot with African refugees. And so one thing,